Very good morning to everyone. It's wonderful to see all those who have joined here for the release of the WAN-IFRA Media Laws Report. It's an initiative of WAN-IFRA's World Editors Forum South Asia chapter, and it's supported by Konrad Adenauer Stifter. A little bit on the report. As most of you might already know, in India, we don't have a separate set of laws for freedom of press as such, and it's derived from the general freedom of expression. So this also leads to a situation that sometimes journalists are unaware of what they should do, or sometimes they overstep the line. So this report is conceived with the idea of giving journalists a better understanding about how several laws can impact their work, and how media organizations have been getting impacted from time to time, how laws have been misused against journalists from stopping them from telling the truth. Case studies have been included, interviews, and of course, a few tips for journalists. And this has been prepared with inputs from several dignitaries in the media sector, as well as from the judiciary, so as to give a balanced reading and understanding for the readers. But enough on the report from me. We have more people to talk about it. So without further ado, I invite WAN-IFRA South Asia Managing Director, Mr. Makhdoom Mohammed, for the welcome address. Welcome, Makhdoom.
Yeah, thank you, Shilpa. Good morning, panelists. Good morning, ladies and gentlemen. It's a pleasure to talk to you all through this virtual medium, and thank you for joining us today. This report on media laws is the hard work of the last 1 year. It was first mooted at the meeting of World Editors Forum South Asia chapter in September last year. And our members felt that handbook on the subject to be a good service to the journalist community in the region. With increasing number of legal cases on journalist community, and also the plethora of laws impacting the work of journalists, a report would sensitize the journalist to report in a confident and informed way. Therefore, we are here today for the launch of this report. The report has the white paper on media laws that Mr. Mukund Padmanabhan, chairman of our World Editors Forum South Asia chapter, authored for the Editors Guild, along with Mr. Anantnath, managing director of the Caravan. It sets a framework for this report. We are grateful to Mr. Mukund Padmanabhan and to the Guild for consenting to use the report, the white paper in this report. Often I heard from colleagues that media laws is one of the boring subjects taught in the journalism schools. But it is something we all can't do without it, as a simple error of judgment could lead to legal consequences. Many times the loopholes in the law are used to suppress dissent and the right to information. And often the process becomes a punishment. The report points to several solutions to the issue of issues of laws. It talks about tougher civil defamation rather than criminal defamation, self-regulation in media, independent commission to dispose of cases swiftly, and so on. One thing that is clear is that journalists have to be aware of the laws that concerns them. And today our expert panel will tell us the way forward. I'd like to thank our panelist, Mr. Mukund Padmanabhan, chairman of our South Asia chapter, Mr. Mahfouz Anam, editor of the Daily Star, Ms. Geeta Ramseshan, advocate of Madras High Court, and Mr. Krishnadas Rajagopal, who is a legal correspondent for the Hindu in Delhi, for joining us today and sharing their insights. We look forward to hear from them. And this report has been possible in a printed and published form, thanks to support from Konrad Adenauer Stiftung from Singapore. I'd like to thank Mr. Christoph Grabitz, who is the director of Media Program Asia at Konrad, who helped to support this program, support this report. And I hope that he will join us shortly. And to my colleague, Ms. Shilpa Elizabeth Abraham, for putting this together, this report. It gives us immense pleasure to present this report to you, and we believe that you will take much benefit from this. And we also hope that this handbook will become a reference book for all the journalists in the South Asian region. With this warm words, I hand this session back to Shilpa. Thank you.
Thank you, Mr. Makhdoom. So now we are moving on to the release of the report, but before that, again, would like to mention a few names. The lead article in this report, as Makhdoom already mentioned, is the white paper written by Mr. Mukund Padmanabhan, former editor of The Hindu and The Business Line, along with Mr. Anant Nath, Managing Editor of the Caravan for the Editors Guild of India. But not just that, Mr. Mukund, who is the chairman of World Editors Forum South Asia chapter, has helped us during all stages of preparation of this report leading up to this very event. With us is also Advocate Geeta Ramaseshan, who has helped us with her valuable inputs for this report and has been very supportive all along. And she makes media laws a very interesting subject, unlike what Magdu mentioned earlier. Then also editor of the print, Mr. Shekhar Gupta, and additional Solicitor General Madhavi Diwan have been the two other people who helped us tremendously to bring out this report. However, due to prior commitments and personal reasons, they have not been able to make it here today. So now I request everybody who helped us with this report to join us to release this report. Mr. Mukund Padmanabhan, I would like to request you to release the report, and Ms. Geeta and Mr. Magdum, please join Mr. Mukund in releasing the report.
Mukund, would you like to?
So, a release report means to hold it up. Okay, here we go. Maybe everybody else can hold it up as well. Shilpa, you too?
No, I don't have a hard copy with me. So.
Oh, my. Okay.
All right.
Yeah.
It's okay. I'm sure the audience have got a good glance of the report.
Yeah.
All right.
Magdum, you should arrange to send it to me, please.
Yes.
Yeah. Do that.
So thank you, everyone. So now we are moving on to the panel discussion. Now, today with us is Mr. Mahfuz Anam, who is the editor and publisher of the Daily Star Bangladesh, and Mr. Krishnadas Rajagopal, who is legal correspondent, The Hindu, joining us with joining Mr. Mukund and Ms. Geeta for this panel discussion. So I welcome all the panelists for this discussion. Before we start the discussion, today we are here to talk about essentially how free our press is, or how much freedom is okay for the press. From time to time across the world, there have been efforts to gag the media or rein in the journalists to stop them from telling the truth, often unpleasant in nature for someone else. This has often been done by misusing existing laws. Even as we talk this, if we look around, we see instances of journalists being hounded, could be for a story or sometimes for something as simple as a tweet. But at the same time, people have a right to reputation, they have a right to privacy, and we have to admit that there have been instances of journalists crossing the line. So again, if we look around, instances are aplenty where the media themselves plays the role of the judiciary and goes about during media trials, turning their cameras into the private lives of people, destroying reputations. It's quite a complicated situation. And I believe the esteemed panel here would be able to bring out quite a few insights on this particular situation that we face. So let's move on to each of your opening remarks. Mr. Mukund, would you like to say a few words?
Yes, thank you very much, Shilpa. First of all, I'm just very delighted to be with a part of this panel. Krishnadas is someone who I've worked with as a colleague for some years, and someone whose work I've admired hugely. Geeta, of course, is an eminent lawyer, and someone we know her views on many things. We've read her as well. And my friend Mahfuz from Bangladesh, who's I think one of the best journalists from that country, and someone I've had lots of conversations about a whole lot of issues concerning the media and politics and other things. So thank you very much for including me as part of the panel to discuss this. I just want to say a couple of things by way of opening remarks. It's not going to touch on the many things that you raised, Shilpa. When I was asked by the Guild to write this report on media law, the first question that sort of came to my mind is, what is media law, or what are media laws? So I actually picked up the phone and asked a friend, can you define this for me? And maybe he was not listening very closely, and he said, anything that relates to the media. And I thought of this, and that anything that relates to the media is obviously too broad. So many laws do, the Industrial Disputes Act does, tax laws, perhaps labor laws, custom duties, whatever. So then, I thought, what about anything that relates only to the media or something that is media specific. And if that's the way you define a media law, then it becomes much too narrow a subset. It may apply only to a few statutes, such as the Working Journalist, Fixation of Wages Act, or some press registration law, or something to do with newsprint, if you assume that newsprint is only consumed by the media, which I don't think it is. But the subset becomes much too narrow. So if you're looking for a definition of what is media law, then you need to say something like anything that has a fairly direct bearing on the media and its functioning, and fairly direct, and it's a promising definition, but it's somewhat vague, somewhat ambiguous. And I think when we talk of media law, we work with that ambiguity about what constitutes media law. But even for a project like this, which the Guild was dealing with, it struck me that media laws fall into two kinds of categories. Those that talk about, if you talk about relating, those that relate to the business side of the media, and those that actually have more or less a direct bearing on the issue of media freedom. And here again, it's not a watertight distinction, because you might have something that relates to the business side, which has an effect on media freedom. Newsprint is a good point. There was a newsprint control order in the 50s, and we know governments used it to sort of, check the power of newspapers. But this is a distinction that the media itself has recognized in a way, what concerns the business side and what concerns the journalistic side, if you like. For instance, the slew of law and regulations on newsprint price, wage boards, customs, licenses, registrations, all of it, which have traditionally been the preserve of the business side. On the other hand, you have a slew of laws that have more or less direct bearing on media freedom. They include defamation, contempt, privileges, hate speech. They apply to others as well, the Official Secret Act. But these are the laws that occupy the mind of editors and journalists. And in a media industry, it's interesting that we have a body like, say, the Indian Newspaper Society that is focused on the former subset of the laws, and a body like the Editors Guild, and of course the World Editors Forum as well, which is occupied more with the latter subset of the laws. I mean, those laws that we think have a more or less direct bearing on media freedom. Which brings me to my second point, and I'll try and be as brief as possible. The other, I think, large issue as media people that we need to confront is, where does the problem lie? Does it lie in the law or laws themselves? Or does it lie in the flaws in the way our justice or prosecutory system works? And I think our responses to this question determines, or at least should determine, our positions on this law. And I'll just give you some examples and be very brief and sign off. For instance, you might argue that a law such as sedition, 124A, just arguably just needs to go, be repealed. Maybe, just maybe there is a case for retaining some statutes, but scrapping some particular provision or article in it. For instance, it's maintainable perhaps that the Contempt of Court Act should remain in our statute book, but that the provision relating to scandalizing the judiciary, which is a very, very arbitrary and subjective one, needs to go. And we've dealt with that before. I mean, the Supreme Court struck, the IT Act is fine, more or less fine, but 66A was a huge problem, so it was struck down, and the courts did that. We also need to think differently in certain other cases. I mean, criminal defamation is an example of this. We might be all opposed to it, but we need to think of, hey, if this goes, what do we have in its place? And that's sometimes an issue that the media doesn't think of too deeply, because do we strengthen the civil defamation justice delivery system to offset criminal defamation? Because if you didn't have criminal defamation in it and you had a very, very weak civil defamation kind of redress in civil defamation cases, where do we stand? Is there any kind of redress at all? And then again, on the other side, on the flip side, what are the implications of a very, very strong and effective civil defamation process? Will this have a chilling effect on free speech? I mean, take Britain, for example, where it's become the libel capital of the world. Is that where we want to go? So I think we need to think the alternatives through as well in some cases, and not merely stop with just calling for the scrapping of this or the repeal of something. So two questions. One is definitional aspects of media law. The other is, where does it lie? Does it lie in the law itself, or does it lie in the misuse of the law and the way it is allowed to be misused by sometimes the criminal justice system itself? I think these are the two questions which I think are important in a sort of very general way. Thank you, Shilpa.
Thank you, Mukund. I believe we would be able to bring out more on those two aspects which you just mentioned. Ms. Geeta, would you like to say a few words?
Good morning to all of you, and thank you, WAN-IFRA South Asia, for inviting me to share a few of my views and to participate in this panel. And at the outset, I must congratulate WAN-IFRA South Asia for bringing out this report that is actually really like a ready reckoner with large chunks of media law that have gained a lot of prominence today. And the discussion point, Mukund, especially with the questions that you have raised towards the end, are actually a great point of reference, I believe, not just to media persons, but also to lawyers to take the whole debate forward, because it's very nuanced in many ways, and it's really not the hype that you see one area from one to the other. I know a lot of issues will come through the discussion, but I just want to share a few points. And one is that we see very strange phenomena nowadays. Most of it will come in our discussions, of course. But first, I find two issues. Number one is a social pressure is created, such as protests, etc., about an article or a movie or a book. And then the state, instead of protecting the rights of the person whose expression has been affected, like, the movie Padmavat, or in the case of Perumal Murugan's book, you find that they go about suppressing the right of the individual. So some states banned a movie, some states ban a book, and then somehow or the other, when the matter comes to the court, it gets rescued, but by then it crushes the individual in more ways than one. The second point of reference that I would actually show is the direct um, use of legislations and its implementation. The judiciary comes a little later, but the application of the law by the criminal justice system, the state, the police, etc., is extremely problematic. Like, for example, the way sedition is implemented. Again, this comes from the larger community. A pressure comes. I mean, how do you determine words? Who determine what is words? I mean, what are words? Anyone finds certain things objectionable, they go to the criminal justice system, and then the whole process starts in more ways than one. And Mukund, very much so, the judiciary also has a great role to play in this, in terms of accepting, rejecting cases, not granting certain rights such as bails, etc. The third point that I would want to actually stress on this is that the interplay of various offenses that the media has to face. For example, not just media, of course, anybody who has their freedom of expression. For example, sedition. Sedition is not a standalone offense today. It's always used along with other harsh offenses, such as the National Security Act or the Unlawful Activities Prevention Act, making it much more strenuous and taking it away from the realm of mere freedom of expression. The other example could be, like, for example, defamation, which one thought of always as an individual right. Mukund, very much so. I believe that defamation ought not to be thrown out from the from the legal process, very much like what you said. But when you say that defamation, what was always considered as an individual wrong or a wrong against a structured organization, for example, a company or so on and so forth, today is being considered as a wrong to the larger community, you know and this combined with obscenity and outraging religious feelings, which we saw interplay very well in MF Hussein's case, brings about a whole lot of oppression, you know and the fourth point again, which I think Shilpa mentioned, which I would just think we could look into, is how do you address privacy and the rights of individuals, especially when they are accused? So for example, a section of the media who takes it to extreme, what we say trial by media becomes extremely virulent and violent when it is there on television every day. um, for example, the most famous case today, Sushant Singh Rajput and Riya. When this comes through in such a big manner, the media becomes far more powerful than even the legal system and the courts. And so then, how do we look at the rights of people who are weaker? Because media is a very powerful institution. How do we look at protecting the rights of those who are a bit weaker when compared to this powerful institution which they have to face? This also can kill, emotionally. I mean, it can really ruin people, you know. I mean, starting from landlords asking them to leave the premises to losing their jobs in a very small manner. You have much more greater issues at heart. So, therefore, these aspects are just some of the complexities that face a great challenge today. And a large part of the points that have come through in your report, actually each point can actually debated and taken forward in a much greater manner. And I think this should be just the beginning of WAN-IFRA South Asia report, and I hope you take it forward in a much more bigger way. Thank you, and welcome to all of you.
Thank you, Ms. Geeta. Those were some very important, pertinent points that you made there. Now, we would like to hear what's happening in Bangladesh. Mr. Mahfouz Anam, would you like to share a few words with us?
Thank you very much. I'm delighted to be a part of the process. I am also, I would like to congratulate the South Asian chapter, WAN-IFRA, and others for taking this initiative. Actually, a comprehensive view of the media law is definitely very important. I think the point that journalists should know the laws that govern them is of utmost importance. I really have a lot to say, but for the brevity purpose, I'll just confine myself to a new set of threat to the freedom of the press, which Mukund didn't touch, is the whole realm of digital space. You see, now newspapers, uh, for their own existence, have to be in the digital space. Each newspaper has a news portal, they have their presence in the digital space. And in fact, we are becoming a 24/7 news institutions, even though before we were, once a day or maybe several editions a day newspaper. Now, this juxtaposed by the global attention on terrorism, and terrorism being greatly facilitated by the cyberspace, governments have started making laws for the cyberspace. Now, for example, in Bangladesh, we have a Digital Security Act. Now, the purpose of this Digital Security Act was to prevent, exploitation of the cyberspace for anything, defrauding, transfer of money. There has been a case of Bangladesh Reserve Bank, which we call the Bangladesh Bank. Its foreign reserves were siphoned off by some criminals in the Philippines. And I think $87 million just disappeared from Bangladesh bank's account. Now, it was meant to prevent these sort of crimes, including the crimes of spreading, religious hatred and blah, blah, blah. But in making the law, they have brought it into the media space. For example, there are issues of defamation, there's issue of national security, there's the issue of, state secret and all that. So this law, which is not purposefully made for the press or for the media, but made for the cyberspace. And because each media is now present in the cyberspace, this law is impacting on the freedom of the press, freedom of expression, freedom of the media. Now, this law, if it was purely meant for the press, for the printed media, there would have been a hell raised all over. It would be against the freedom of the press and all sorts of things. But because it is focused on cyber issues, there was not such public reaction. But in reality, it hampers the press much more than any law ever did. And the 2 years that it has been now in implementation, more journalists have been arrested than, if you like, the cyber criminals. So ultimately now, this law provides for, a very vague and large expanded notion of reputation. And now, if we write anything against an MP or even a businessman, the first thing they do is lodge a case in the under the Digital Security Act. They don't go for anti-defamation. They don't go on for the old laws. They go for this new law. And in this new law, there are 20 provisions for punishment. Out of that 20, 14 are non-bailable. And this 14 covers everything. There's an enormous power given to the police, who on suspicion can come into a newspaper's office and basically confiscate the internet network. A policeman may think that there is an anti-terrorist message in my network, and he can confiscate it, by doing which he can effectively stop the publication of the newspaper, at least for 24 hours. Now, normally, for a government to stop the newspaper publication is a huge violation of everything. But in this, under this rubric of security, they can easily do it. So this has greatly hampered our freedom, greatly hampered our operational autonomy. So I would like to strongly suggest that a second edition of this media law should now be to include the cyber laws. And this is the new frontier. This is not only happening in Bangladesh. I'm sure if you look at it, it is happening in India. Definitely it is happening in many parts of the world. This is the new frontier through which governments are coming into the doors of the traditional media. And because there is a global acceptance of terrorism as a threat, the rise of surveillance state, the capacity of governments to really do surveillance on its people, including journalists, is now an enormous threat. So I don't want to go into the other issues that Mukund faced, but just to say that under the overall rubric of rise of populism, of rise of nationalism, of the rise of national security state, media is under tremendous pressure, especially through laws that are they're apparently made for the digital space, but in reality, it comes to the press. Thank you.
Thank you, Mr. Mahfouz. That was a very impassionate short speech.
Bengalis were never short of passion.
I'm sure. I'm also sure WAN-IFRA South Asia and World Editors Forum South Asia chapter would definitely give a thought about bringing out a second edition of this report covering the whole South Asia region. Now over to you, Mr. Krishnadas Rajagopal. You have been someone who has been at the intersection of law and journalism. So what would you like to say?
So, thank you for the opportunity. Now, the thing is that we have a senior lawyer and two distinguished editors to provide their detailed views on the laws and the application. What I may be able to place on the table is a first-person account of what happens in court, the Supreme Court, when issues of free speech and criminal contempt of court are heard. Now, over the past few months, there has been, in my view, an increase of cases concerning these subjects. Journalists booked under UAPA, the Unlawful Activities Prevention Act, and sedition laws come to the court for protection of their personal liberty. On the other hand, the prosecution or the government oppose on the uniform ground of national interest, national security. The court's response in these cases are mixed. They range from giving hope to being a cause of despair, public despair. Habeas corpus petitions are adjourned for weeks. Now, I can summarize a few instances, a few anecdotes from my own reports. In June 2019, a Supreme Court bench, it was a vacation bench led by Justice Indira Banerjee, ordered the immediate release of journalist Prashant Kanodia. Now, he was picked up by a few plainclothes men in UP and detained for certain tweets that he made against the Chief Minister of Uttar Pradesh. Now, Banerjee, while ordering his immediate release, agreed prima facie that these kinds of tweets should not be made. But arrest, in fact, she said, we live in a country where there is a constitution. Proceed against him in accordance with law, but should he be behind bars? And then she paraphrases Spider-Man's uncle in the movie and tells the state council that with great liberty comes great responsibility. Now, this was in 2019. Juxtapose this with the recent hearing of a habeas corpus petition filed by the Kerala Union of Working Journalists for their secretary, Siddiq Kapan. Kapan was detained with some others on his way to Hathras in UP, the recent case of rape and alleged rape and murder. The petition was filed before he was booked under Unlawful Activities Prevention Act, UAPA. The SC this time asked the union to go to the correct court, which it said was the Allahabad High Court. When Mr. Sibal, who was appearing for the union, said that this delay would cause Kapan to spend time in jail, probably 6 months, considering the pandemic situation and all that, the court simply, it was Chief Justice Bobde's court, simply shrugged and said that, you can't be so pessimistic. Now, another case is that of senior journalist Vinod Dua, which came to the Supreme Court. Dua came to the Supreme Court to quash a sedition FIR registered against him for his YouTube broadcasts. His defense was very simple. The case was the broadcast was regarding his comments about the government's alleged lack of preparedness for the pandemic. Now, his defense was very simple. He just said that fair criticism does not amount to sedition. But the state council, while hearing the case, said that his broadcast violated a March 31 directive against unverified news. The state council even went about to say that journalism can hardly be qualified as a profession. He said, where is the professional client relationship here? So it doesn't come under the definition of professional. This is hardly surprising because one of the top law officers compared journalists to vultures recently. Now, this being said, I've also noticed cases, as Advocate Ramaseshan had said, cases where certain sections of the media, embark onto media trial and pry into personal lives and all that. But the more immediate is how certain sections of the media are criminally defaming entire communities. For example, there is a petition filed by several petitions filed by organizations and individuals on how the media portrayed the Tablighi Jamaat incident. Another case is that of Sudarshan TV, which is sub judice. But without going into the facts and merits of the case, I just like to point to one application filed by author Kota Nilima. She says there is a steady and almost irreversible trend clearly visible these days, whereby the TV anchors and TV debates have debased and degenerated themselves into blatant purveyors of hate speech. I'm quoting from her application. Now, at this point, I'm reminded of what Justice K.M. Joseph said in his separate opinion in the Raphael judgment about how bias affects journalistic ethics. He said bias may stem from personal, political, or financial considerations. Transmitting biased information betrays absence of true freedom. And he said bias affects judges as well as journalists. Now, in the Sudarshan case, the court is right now considering the setting up a committee to make recommendations for strengthening the self-regulatory mechanism for electronic media. Importantly, it's also examining what constitutes hate speech on air. But on a skeptical note, is this the job of the court? It kind of reminds one of 2012 when Chief Justice Kapadia tried to judicially lay down what court reporters should report and what they should not. It's certainly a delicate problem. Moreover, the dissemination of news and views have taken on myriad forms, with the onslaught of social media, YouTube channels, Twitter, other social media platforms, WhatsApp. There's a deluge of information. From what I could gather, I read the report, from what I could gather is that, fundamentally the judges are finding contempt of court as a provision simply ineffective. There's too much coming onto them. And this situation can be correctly depicted when senior advocate Rajiv Dhawan in Prashant Bhushan's contempt case asked Justice Arun Mishra, he asked him, what are you doing? The tweet that Mr. Bhushan made has been shared probably hundreds or thousands of times. Who all will you hold in contempt? So the issue is complex, it is multi-layered, and it needs discussion, especially the social media, because it's double-sided, and we have to address both sides. Thank you.
Thank you, Mr. Krishnadas Rajagopal. We now have a short video from Ms. Madhavi Devan, Additional Solicitor General, who helped us tremendously with her inputs for this report. So can we have her video, please?
Congratulations to WAN-IFRA for coming out with this media law report. It comes at an important time, and this is something of pressing importance because ultimately the law is not for lawyers alone. It must be shared and understood and applied by all stakeholders And when it comes to media laws, laws which impact the freedom of speech and expression, it's something that must be known by and understood by not just journalists and media persons, but also members of the public. Because ultimately, and particularly in the age of the social media, this is something that impacts every citizen, because each one of us, even when we use our smartphones on a daily basis, every hour of the day, for some of us, every minute of the day, we are, in a sense, applying and using our freedom of speech. So this is something that impacts not just media persons, but the public as a whole. I think one of the big developments that we've seen in the last about the last decade and a half is the huge emergence of the social media. And on the one hand, it has been phenomenally liberating and empowering for the ordinary citizen who before this perhaps didn't have the kind of voice and reach that the social media has afforded. So it is, in a sense, a very democratized media. It's a for the people, by the people, of the people kind of media. But at the same time, as we know, the social media can be a very shallow medium. It can be very superficial. The social media is not a fact finder. And therefore, I think it can be, as we are seeing, it can be a cesspool of misinformation, of hate speech, which is so difficult to regulate, and also creates a kind of perhaps a polarization in society, and sometimes obstructs a real understanding of issues. So I think that this is a time which is really very important for the conventional, the institutional media to come forward and assert its space, because it's something that is needed perhaps more than ever before. Because ultimately it is the institutional media which will be accountable as a professional media, unlike the rest of the social media. And therefore, newspapers, whether online or offline, generally the institutional media is a very, very, occupies, in my view, a very, very important space, perhaps more than ever before, when you are competing with so much misinformation and, very shallowly expressed information. So I think that, the conventional media, the institutional media has got to assert itself, because ultimately it is that media which really plays the vital role of a public trustee, because it really determines what we as members, ordinary members of the public, what we know or we do not know, what we see or do not see. And therefore it impacts the quality of citizenry. So, when, for example, when we see sometimes the media very disproportionately focusing on issues which may not, shouldn't perhaps, occupy so much mind space or so much newspaper space, then perhaps what's really happening is it's taking us away from issues of national or international importance, something that should acquire, should occupy some mind space for us as citizens. And so therefore, in this sort of din of perhaps a very sensational or very shrill coverage of certain issues, I think what it could lead to is a dumbing down of democracy, which is very, very serious. So therefore, I think it is time that for the media to really pull itself up and assert itself. And of course, there is a need for all of us, whether media or non-media, to educate ourselves on various issues, including, of course, our constitutional rights, our fundamental right, and the real content of 19(1)(a), the content of Article 19(2), similarly, other laws on defamation, contempt of court, privacy, which is now a fundamental right. in the manner in which we report is sometimes so violative of the privacy of individuals. So this is also a very important right. Then you have the right to information. You have, for example, on reporting proceedings and how that interplay takes place with the contempt of court, because more and more people are reporting, they're tweeting from court. So it's very important to understand what the Lakshman Rekhas are. And we are in a very fluid situation with the emergence of the social media, and the social media also reporting the calls. So I think ideally, we should have much stronger self-regulation. And we have to, I mean, the media's got to try and build stronger and more credible institutions for self-regulation. That's the only way really forward. And ultimately, I think, generally on the freedom of speech and the right to dissent, I think they're not just rights in themselves. They are ultimately a means to an end, and that end being the throwing up of new ideas, of new thoughts, which is really the sine qua non of a progressive civilization. And therefore, we've got to somehow, out of this sort of cacophony and noise which surrounds the media, we've got to somehow try and sift out the new ideas and the new thoughts. And for this, I think we've got to educate ourselves a little more on the laws. So thank you very much, and congratulations again.
Thank you, Ms. Madhavi Diwan, for those wonderful words. So I have one request for the audience. You could post your questions in the Q&A section, and we would take it as we go along. We already have a few, 3 or 4 questions here, and it's wonderful to see all those questions coming in. So let's keep this a free-flowing discussion. And of course, I have a lot of questions for all the panelists here today. But would any of you like to start with a few questions? Mr. Mukund or Ms. Geeta, Mr. Mahfouz, Mr. Krishnaz, anybody?
Yeah, I mean, I was just responding to Mahfouz, who is not here now. I think he makes a fair point that, I mean, others have also, that the digital media has kind of upended the state of play in some respects. But there are, as far as media law goes, the slew of laws that apply to, the main bulk of media laws that apply, at least in connection to press freedom. I mean, it's irrespective of medium, it goes on to space. And while I do grant that, I've read a little bit about the Bangladesh law after he flagged it a few days ago, and I understand that the anxieties when you have a system where people are arrested and proceeded against and so on and so forth. I am rather struck by what, by what Krishna Das and to some extent Madhavi has also said. I mean, we're living now, I mean, we see in the social, in the digital media space, just as journalists, we reflexively see governments as the sort of threat, the biggest threat to freedom of expression. I think there's a good case for continuing to see it that way. But there's a sort of new elephant in the room, if you like, and that's and we're learning about that. The extreme power that companies like Google and Facebook and other digital media companies have to reap data from every one of us. And it isn't as if, this is not a threat. I mean, anyone concerned with threats of privacy, anyone concerned with threats of, trying to ferret information out of you or trying to even modify or change your behavior, which is akin to pamphleteering. It's not good journalism. I mean, we know that the algorithms that these companies write are sort of designed to modify you, designed to make you more, addictive, more engaged, more angry, if you like, sometimes. And there's a whole lot of literature and books which have now emerged on this, written by professors and people in the profession. The most popular, of course, which has got noticed now, is this film called The Social Dilemma, which is now on Netflix. But there's a whole lot of stuff written before that as well, dating back to 6 or 7 years ago, when this New York professor, maybe it was 8-10 years ago, wrote this book called #Republic. This man called Cass Sunstein. I remember reading it and talking about it, and when people thought the ideas were really far-fetched. And the idea basically was, here is something that is changing the way that we think and feel. So I think if we are concerned, I think we need to flag this concern as well. I think it's huge. And these are media companies in some way. I mean, I don't really know whether Google and Facebook or anything else. And then the other aspect of it is, I think it's also important to look inwards in ourselves, the legacy media, for instance. We're also learning this little game in our own little ways. We are designing websites so that we serve more of the same to somebody who likes something. These are intuitive things. So the kind of intelligence that goes into, at a mass scale in these big companies is sort of playing out in smaller ways here. So I think there's a case for asking ourselves what we're doing too. And I'm not negating anything that Mahfouz said. I admit that, we still need to be extremely cautious about what governments are doing and protesting it. But I think at the same time, we need to look beyond governments and look at A, principally the big media companies, and B, whether we are following some of these ills that are happening in the digital space. This craze for speed, this craze for mistakes that are happening, they're happening in legacy houses. Is there the same degree of fact checking when somebody wants to, I don't know, Krishnadas would answer this more accurately, but there is probably a case for thinking that a reporter is likely to make a greater mistake if he has to file a report in, say, 40 minutes of a court session being over than, say, 5 or 6 hours. But in a culture where everybody has to be there first, everybody has to twist the news, clickbait headlines, for instance, these are not accuracy. So I think, granted, I think at least when it comes to the digital media space, I see the law. I mean, I talked about the Indian law. I mean, it does not that we mentioned, didn't mention it at all. There was 66A in the IT Act, which was a problem, rather like, the Bangladesh Act in some respects, which was struck down. Nepal has an act, which is again problematic. But I think the digital media is bigger than this. I mean, they're different people in the game, and we're all in it in some way. And we need to look both at the big digital media companies and inwards, which is the point I'd like to make.
Just like to point out here that, it's kind of what Mukund said is that, it's very interesting in the sense that institutional media houses, in fact, encourage their reporters to tweet, to use WhatsApp. The office messages are sent on WhatsApp, not text, WhatsApp. There are groups formed, National Bureau, there's separate groups formed, probably confidential documents. In my case, court documents are shared on WhatsApp. So there's a huge trust. I'm saying a blind trust being put on these companies. And the several cases that concern or where a Twitter or WhatsApp or Facebook is a party in the Supreme Court. And the uniform defense that they take is that we are just social media intermediaries, and we don't have a responsibility here. We don't have a responsibility to come before you. We are outside your jurisdiction, basically. So this fact that, even institutional media houses, I believe that there are some media places where, reporters are said that your salary, your perks are dependent on how much you tweet and how much you WhatsApp, how active you're on social media. So I think that's probably a cause for concern, if not at least for consideration at one point. How media houses are dependent on these social media platforms for day-to-day functioning.
Thank you, Mr. Mukund and Mr. Krishnadas. So I have a question for all the panelists. It's something which concerns India as well as Bangladesh and probably other regions in South Asia. So if we look at the World Press Freedom Index 2019, India figured, I think, at 140th position out of 180 countries, and Bangladesh was 150. So both these countries have slid down their positions from the previous list. So is this an indication that things are worsening in South Asia region, or are we seeing some kind of hope of things getting better? So I would like to know what all of you like to say about this.
May I come in now? Yeah, no, I think definitely there's a slide down in the freedom aspects of our societies, and there's a combination of things. I said earlier, nationalism, populism, religion-based ideas, which really you can't question. But I would like to signal another thing. You see, after the Second World War, the democratic structures of each society, or democracies were structured on a concept of division of power and check and balance. So we had an elected government, we have the legislature, and we have the judiciary. Each of them had a function of supervision and check and balance. What has happened in the recent past, I would say last 20 years, is the rise of the executive branch of this three-tier check and balance structure. The executive branch comparatively are far more powerful, and they impact on the parliament. In a parliamentary democracy, the majority party in the parliament forms the government, so there is an influence there. And then the judiciary. Judiciary is also increasingly under the influence of the executive, particularly from the through the appointment process. So the balance is now gone, and it is tilted towards the executive branch. And that executive branch has now been further strengthened by the surveillance technology, by the amount of tax money that they control. And through that tax money, they can influence the agenda of the society. And this has created an imbalance which has negatively impacted on the freedom structure on which journalism depends. Thank you.
Thank you, Mr. Mahfouz. Ms. Geeta, would you like to make some comments on that? Does it mean that laws are being more and more misused to curb the freedom of speech of journalists?
Me think a lot on that because I don't think we think on those terms, but yes, it is a fact that it is the executive that will actually start the process of dealing with every any person who they would want to see as an offender. I would say they would want to see them as an offender, just so that one can control. And I think especially in many of our regions where especially with reference to um, smaller media, so to speak, in districts, etc., you can arm twist them to such a large extent, especially young reporters, um, reporting from rural areas, etc., that there will be a conspiracy of silence. I mean, the best way is to arrest 5 people and put them in a particular area, with all the powers that the executive has at their disposal, and the remaining 10 would be silent. They wouldn't want to respond at all because they are very successful in creating the element of fear. And they have the power to create the element of fear. And I think Mr. Mavsoos has made a very valid point in this regard.
Thank you, Ms. Geeta. Maybe we could take one question from the audience. So there is one question, an interesting one from Vakasha Sachdev. Back at the time the constitution was drafted, Ambedkar actually opposed the idea of of right to press freedom. While India's restrictions on fundamental rights would probably mean even this right wouldn't necessarily mean a huge deal in the court themselves, could having right to press freedom separately have led to more of a culture change so as to not attack journalists for their work. So would somebody like to take this question? Mr. Mukund, maybe.
Yeah, I think you asked me this question, or at least, yeah, a sort of similar question in the interview, which is in this document. And I think my response, if I remember correctly, was yes, I think it would. And yes, I think it would, not because it would materially alter anything apart from being there. You might argue that a derived right is, or an implied right is as good as a right there. But I think just having it in, just like you have the First Amendment in the States, having it in there would have, I think, exerted sort of such a strong symbolic power that it would have, I think, had a real effect in maybe, and I'm arguing this counterfactually, it's something I cannot establish, but I think, it is something that we could just turn to immediately and say, hey, what about this? It's there in our Constitution. So yes, I think the presence and absence of words make a difference. I can't materially prove this, but I think the symbolic power of having it there in your Constitution in some way would have made a difference, material difference.
Thank you. Mr. Krishnadas, I have a question for you. So you have a background in law as well as you're a practicing journalist. So how important do you think is the knowledge in law for a journalist, especially if you're working in a legal bureau?
Well, it's convenient if you have a knowledge in law, but I don't think that's a necessity because, it depends on the interest of the person covering the courts. There's several successful journalists who don't have a background in law, but learn on the job. And it's basically interest and curiosity that lights your path. But yes, if you have a certain knowledge in law, if you have a degree, then when you're reading the statutory books or when you're going through the legalese, it helps you save time, that it helps you give a perspective, which I think takes time for a person who doesn't have a law degree. So that's all the difference. But, it's practically, it doesn't make any, I mean, it's just the person who's on the field. It's his interest and curiosity, as I said.
But how often would you see these encounters between, media and law? How often have you seen it during your career?
The encounters between media and law.
Yeah.
Sorry. It's in the sense that this is a particular branch of reportage. I mean, you are fundamentally a reporter. It's just that you cover a certain institution, and which has a certain, in my case, the Supreme Court. And as you go on with your daily reportage, you basically, the thing is that, for example, you get to know that there's certain observations or remarks made off the cuff by the judges. And I think as the years go by, you restrain yourself. I mean, not censor, but restrain yourself from making, because these remarks or observations are not fundamental or important or quintessential to the case or the outcome of the case. So I guess if you have a law degree and if you're an experienced reporter, you kind of balance. It's a balancing act, and you don't cross the certain limits. And you have to say what is the truth in a particular case, and that's it. There's no confrontation as such. It's just that you take it all along with you.
Thank you. I think we could take another question from the audience now. There is a question from Mr. Naresh Khanna. Maybe Ms. Geeta, maybe you could take it. Now that our constitution is about 70 years old, is it not simply that the media or any law is not merely what is written, but the history of its practice? Should the media need to go to the courts to establish more local legal precedents?
Okay, I'll add to what Krishnadas said and then answer the question. I think
Yeah.
Krishnadas made a very valid point about not writing certain comments which judges would make in the court, because sometimes when we practice and we know that sometimes things are said in a fit of temper or stress, judges do make those kinds of comments. And we just tend to ignore it or laugh it off after the comments are made. But today, any comment made by a judge is immediately tweeted, or uh, comes into a different kind of an arena, which we would have completely, which a lawyer or the legal people around there would have completely ignored. And I think that aspect, what you said, Krishnadas, is very valid. Now, as far as this question is concerned, yes, Constitution is 70 years old, but all our constitutional rights, which actually stand on a much higher footing, are derived from there. you know Otherwise, if they didn't exist within the constitution, they would have just been pure civil rights, which may not have had the kind of um, sanctity that is required. But on the second aspect, where you say whether the media can take these to other smaller other courts, yeah, there was always a discussion for a long time, even in the 80s, when when the Supreme Court judges, some of them, especially Krishna Iyer, had felt that Article 32, which provides for the enforcement of fundamental rights, the powers of Article 32 should be actually given or made available to the district courts and the trial courts, because after all, not everyone can come to a constitutional court and enforce their right at any point of time. But this was always a point of view that has existed. But somehow or the other, current scenario, according to me, is that the constitution should not be tinkered at all, in any form. And maybe, I mean, if that did exist at some point of time, it would probably be easier for people to get their constitutional rights enforced at a very local regional area. But yes, it is 70 years, and right now I don't see any reason for it to be tinkered in any manner.
Thank you. There's another question from G. Anand. Kerala High Court has an accreditation rule where degree in law is mandatory for court reporters. So can it be made mandatory? After all, we are not reporters of law journals. So if anybody would like to answer that question.
I think Krishna should answer this. Yeah.
See, there is a system of accreditation in the Supreme Court. And the thing is that it's given after a few years of court coverage. It's a long process by which you have to prepare a file of your past work, the stories that you have published, and also you have a law degree. So this is basically the court trying to tell the reporter that you are responsible. This is your institution too, and report fairly. So it's not an aggressive or an adversarial thing. It's just that it gives a certain sense of accountability to the journalist. And also, and this is it's the scene is the scenario is not that only accredited reporters cover the courts. Non-accredited reporters also do, and they have the same equal access, and everything is online. The judgments are online, the orders are online. There's equal access to courtrooms. There's, as far as functional, it doesn't affect the functions of a journalist. It's just that the court feels that yes, we recognize a certain accountability, and we want you to report in an accountable manner. It's just that it's a system that the court has put in place.
Thank you. Mr. Mukund, I have a question for you. We have often heard about how the media should self-regulate itself, but till now, how successful a practice has it been, according to you?
Well, I don't know whether this attempt at self-regulation has been entirely successful, and I don't think it will ever be entirely successful. But I think the question is, what is the alternative? And the alternative is some kind of regulation from the outside, which I think is going to be worse than what we have at the present. So, between sort of strong regulation from the outside about the, the kind of regulation that is envisaged by some governments and some others, and between the state we're in, at least when it comes to some issues, I would prefer the existing flaws or the status quo to something else.
We have a question here from an anonymous attendee. Again, maybe Mr. Krishnadas, you could answer it. I'm a beginner in media profession, and I often go wrong with familiarizing legal terms because apparently it's not for a common person.
So can I take that before Krishnadas?
Yeah, sure.
Permission, yeah. So I think this is a good question. I mean, at a sort of larger level, it sort of raises this question of how effectively, as a nation with 26 major languages, so on and so forth, we have managed to translate, this body of knowledge that we have in technical subjects into our own languages. I mean, that's the larger context. But at the sort of more immediate level, I recall at the Hindu many years ago, and this is 10 or 20 years ago, in the Madras High Court, where I've been and hung around for a while, if something interested me, there was this practice where after the judges had finished with the judgment in certain cases, they would call the Hindu reporter who was they trusted in some way as faithfully reproducing what they said. They would brief him in English, because many of them spoke English with his joint judges. And then he would come out and he would render the judgment, actually just take down from his notes and say it in Tamil. But say it in a form that it could be legibly and clearly go into a Tamil newspaper. I've seen this more than once. And I asked around, and apparently, this was almost established convention. I'm not sure it should be done because everyone has a right to hear, the judges speak. But this was more convenient for the Tamil journalists, at least some of them, and more convenient for the judges because at least they wouldn't get it wrong or they wouldn't be asked, too many questions. I don't know what the basis was. So yes, I think there's an issue. I'm sure there is an issue with languages and with technical legal terms. And I think the larger issue is maybe sort of our national failure in being able to. And it's not just in law; it's in the frontiers of medicine. It's in the frontiers of so many things. And our sort of reaction and our defenses have been in shoring up the language. I remember we had this minister some time back who's no more, called Mr. Tamilkudi Magan. And one of his jobs was to invent one Tamil word every day. So you would take an English word, usually from some software development from somewhere, and come up with a Tamil word. Now, I'm not even sure how many of us are aware of it or whether it's being used. So I think we need more organic systems to deal with this problem. Yeah, sorry, Krishnadas, over to you.
I'd just like to add to that, the Supreme Court has a mechanism where it translates judgments into regional languages. I believe there are 10 or 15 languages in which they translate their judgments. And this is for the ordinary person to read and understand. So there is a mechanism where judgments written in English are translated to various regional languages, and I believe Tamil is one of them.
Thank you. Ms. Geeta, you teach media law. So are there some tips from your side to offer somebody who is struggling with this particular problem?
I I don't know, for the print media, it's probably a bit easier because you can, take the news and savor and get it done, later at a later point of time. But with the television media, the pressure is much higher. And I think I would actually ask WAN-IFRA to take up this challenge. I really don't have an answer for that, in terms of one. Of course, it's easy for me to be patronizing and say improve yourself, but that's not what I want to say. But maybe bring out smaller glossaries of frequently used term, like, I've always find police custody and judicial custody not understood by many people. Accused and convict not understood by many people. Very simple, very, very elementary words in many ways. So maybe that could be one aspect. But Mukund, I also wanted to tell you that when they would call the Hindu reporter, they would, they have, of course, the press room, right? Those days it was inside the High Court campus. After some time, when there was a dispute between the media, they were asked to go out. The Hindu reporter would be the one who would read it out to every other journalist, and faithfully every other journalist would then report it in the various newspapers. So it was a very interesting thing, but I felt it was I thought it was very very fascinating, so that there was no wrong reporting of the judgments. Proceedings in courts were not reported so much. The arguments were not reported so much as the correct understanding of the judgment.
Yeah. I was a reporter myself. I mean, I was not a reporter, but I was I was not the editor at that time. So I was, I just would go there when something interested me, and I've seen the process, and I agree with you. I just wondered whether, procedurally it was the right thing to do, but yeah, I've seen it. It worked and suited
Especially,
everybody.
the early 80s, Justice Ratnavel Pandian, all of them would call and tell it to the Hind. That was the credibility of, continues to be the credibility of the paper.
Yeah, no, I'm not talking of the 80s. I'm talking about late 90s, early 2000s. So it continued till then with definitely continued until then. Yeah. I don't know how far along it went, but yeah.
So we have
I just want to add one more thing to what Krishna said. I think, Krishna, I think, is, said, journalists learn on the job. Journalists, can learn other things. And there's an element of truth to that. But I still do believe two things. One is, I think the law is absolutely essential, not just to legal reporters, but to just journalists overall. I think it's a window to understanding government, and sometime in the after I joined the Hindu, I sort of got interested and started writing about legal matters and constitution, and then finally also registered for a law degree, which I finished some 97% off and didn't finish the rest because it just bored me, and I didn't really need it because I was not going to become a lawyer. But and also taught postgraduate students law in Manila. So I think you can pick this up, but it's integral to journalists. I just think it's so central to an understanding of the way government works, just the way things work. So if there's one subject I would actually point to, and this is not just for courtroom reporting, and obviously it would help courtroom reporting, but just for general journalism, I think it would be the law. To me, if some journalist was ever to come saying, I want a job, and he had done law, then it was a huge plus point. It was like, okay, he's sort of, he had already half a step in the door as far as that is concerned.
Thank you.
I don't know whether Geeta agrees with it. She teaches law, so she
sorry, I would definitely agree, Mukund. I think, it gives you probably a different perspective sometimes to look at both sides in a much better and a more nuanced way than Not to say that others will not look at it, but the training comes through a bit.
So the moral of the story is Krishnadas can morph into any stream of reporting simply because he knows he's got the basics right, which I can't think of others do. So it's that kind of advantage.
So in our chat box, we have quite a few demands for daily press briefings from court in simple language and vernacular language. So we hope something on that line happens. So there is a question from Shweta Singh, slightly different from what our report is about still. The social media is having a huge impact on our understanding of reality, more than the legacy media, some would say. Why have the laws in India not been able to check sharing of misinformation, and what can be done? So who would like to answer that question?
Hands up. So I'll just go because nobody else has. Hello? Yeah. So yeah, just because nobody else has put their hands up, this is a problem. If any of you have seen The Social Dilemma, there's a study that they quote there saying that fake news has a 6 times greater probability of virality than true news. So, this is the kind of medium that promotes extreme views, and with extremity comes lies, comes exaggeration, and comes some sort of falsity. So I think it's built into the algorithm in a way that it's promoted. So the idea of how you filter it out is not easy. I think to do. I think it's not just us. I think the world has been trying to deal with this issue of false news, and it's partly to do with the ease with which you can spread something. Just press a button and send it to 5, 10 friends, and they send it to 10 others. But we know now that of all the mediums, WhatsApp is the biggest vector of fake news and misinformation. And, I really don't know. I mean, there is a privacy issue. So unless you want WhatsApp to troll through all your messages, which is not a good idea, I think in a digital environment, it is very important to have at least some channels of communication that are not pried on. We know that even Gmail, the algorithm, they're not spying on you, but they're reading what you say, and what, if you mention a car or an object, then it might show up in your advertising feed sometime later. So your data is being harvested in an impersonal way. So I'm very happy that we have at least some systems which claim to be encrypted and cannot be read by anyone. But I think with the problem with what something like WhatsApp is that if you want to empower it to, or you demand that it sort of reads mails and filters and stops forwards, then it just destroys one of their USPs, which is encrypted and private communication.
Just wanted to add this, this question. I don't understand why people don't choose what they see, because there are, when you know that there are certain handles or certain tweets or certain social media groups that indulge in certain ways of commenting, then I guess you can cross-check with the institutional media or other sources to see what the actual thing is, or you can even balance it. So yes, there is a proliferation, a dissemination of views and news, but then at the same time, you could also cross-check. And that's a basic thing, I would like to know more. Why do you just tend to believe what you see first? This is something that has bugged me, because mostly institutional media have their own websites and their own columnists and reporters. You could check with these sources too.
I think probably that culture of verification is yet to get into our DNAs, maybe. We have this question to all the panelists. Maybe we could end with this. It's almost 12 o'clock. So is it correct that the social media gets away easily, whereas institutional media are the ones mostly impacted by the laws? Can we change this, and how? It's a question to all panelists. So whoever like to go first.
I think Geeta can start.
One is the surfeit of information with reference to social media, right? But I can't say that all instances of social media people are getting away that easily, because if you take Prashant Bhushan's contempt with reference to the tweet, if you see the latest judgment which came 2, 3, 4 days ago of the Supreme Court, staying the not the investigation, staying the Bengal police from coming and arresting someone in Delhi who had tweeted something with reference to the government, but saying that she can come appear for investigation. Where the government wants to come down on you, they can definitely take any social media comment and use it against you. And but only thing is the number of information, the retweets, and sometimes anyone may feel that it is not worth going ahead and getting this done. Especially, it's very true, I think, of individual or scenarios like defamation, etc. But I think there is a precedent and lot of judgments and legislation pertaining to institutional media, so which probably makes it easier for those cases to come up.
Maybe Krishnadas.
Complex issue where the social media is getting away easily on an institutional media, because institutional medias are bound by laws. They have institutional laws, statutory laws, and there is also a sense of fairness, I guess, that institutional media at least tries to portray in news. Whereas social media cannot be compared with institutional media, because what is social media? I mean, it's just an individual's opinion on a Twitter handle. It's not on the same level as probably a newspaper or a channel, I can say. So social media requires certain guidelines and regulations which have to bring in, the government has to bring in social media intermediaries, and they have to write these regulations and guidelines. And, there should be a certain a level of thought and process that has to go in on, you probably need to codify, because comparing institutional media and social media on the same breath is, I think, quite not fair. That's what I feel.
Yeah, I mean, I'll just end by saying, I think Krishnadas drew attention to the fact that one of the defenses that the social media platforms make is that they're just platforms, that they're just carrying information. So by and large, they have shrugged the responsibility for the content that is put onto them, though increasingly in the last 7 or 8 years, at least in the US and in other parts of Europe, there is a great effort among legislatures to sort of find some sort of balance, to say, okay, we'll try and preserve your freedoms, but hey, you can't let anything go. So as you know, Twitter itself has some policies that now govern what can be posted, what can be not. These policies are not laid down in any coherent or consistent way. Sometimes, some sort of a perfectly inoffensive tweet leads to the ban of somebody or his account suspended. Sometimes some really inflammatory stuff is allowed through the door. The allegations of bias which have been made, the Biden-Trump election is a good example. The New York Post stories on Biden were just, just not allowed to go through by Dorsey, and he's been called and questioned by the, by the committee before the Senate on this. So there is all of that happening at one level. The other issue is, and I'm not sure whether the question refers to this, is whether we as who post on social media, which is the large public, whether we are less accountable than we as who write for the institutional media are. And I think this is a question worth examining separately, because I think one of the things that's true is that, we can argue, we can say, criticize the court for coming down on Bhushan for what he said, saying, look, it would have been much better if the court had what Justice Bharucha described in one case, in the Arundhati case, one of the Arundhati Roy cases, as having broad enough shoulders to withstand criticism, and shrugged it out. But I think, look at this. I don't think Mr. Bhushan would have been gotten away with having those lines that he had on the court in any newspaper article, at least in most newspaper articles in the country. There would have been gatekeeping. They would have policed those lines out, and they would have said, sorry, you can't say this in my newspaper. I'm pretty sure about most newspapers. I mean, you might have gone through to some sensationalist tabloid, but most newspapers, and possibly also most websites, you couldn't have gotten away with saying that. Now, that is independent of whether he should have been convicted for contempt or not. I personally believe the contempt law should not be used, willy-nilly in this fashion. But at the same time, I think what this points to is that our standards are much, much lower on Twitter. What leads somebody to say, hey, I can think anything goes on Twitter? And I watched my colleagues, my friends, other people I know, and sometimes I look at the things that people are led to saying on these social media platforms, and I just wonder why they fail to use the same kind of yardsticks or the same standards they would use on themselves when they would say write for a publication, and they don't do that. I mean, the fault is with all of us. We all seem to reflexively believe that almost anything goes on social media. So we're much more critical. We're much more savage. We're much more nasty. We're much more angry. And I think the larger question, I think I refer to this, is, are we being led to being these way by the algorithms in social media? And I think that is the big question that we all need to address. And I think that is sometimes I feel the biggest question that faces the media today is, what is it doing to us? What is the social media doing to us? So I'll end with that. Yeah, thanks.
Thank you, Mukund. Yeah, sure.
Just like to add, I think what Mukund, what I understood is that in social media, there's absolutely no room for nuance. Whereas in institutional media, when you're writing an op-ed or there is an editorial control, and there's also, you can play nuance, you can play out your nuance, you can present both sides of the argument. So I think that's what, that's basically the difference. That's what I want to say.
Thank you, Mr. Krishnadas. So maybe we all can agree with what the legendary journalist B.G. Varghese once said, that what is needed is sensible regulation. Maybe it's from ourselves or it's from the party standing opposite to us. So thank you, everybody, for those wonderful insights. I would like to end this discussion with a statement from former Attorney General of India, Soli J. Sorabji, who said, when in doubt, tilt the balance in favor of expression rather than its suppression. So thank you, everybody. Thanks for those wonderful words and your time. And before we end this session, I would like to tell all the attendees that everybody would be sent a copy of the report. But we aren't planning to stop these efforts with just this report. As a continuation of this, we would be organizing a training on media laws by middle of November for journalists. We shall send you the details soon. And if you're interested, we request you to please register. So with that, we come to the end of the session. And once again, thank you, everybody. Thank you, Magdum. Thank you, panelists. And thank you, the audience.